Hi guys, it's Kathy. I hope you're doing well. So I promised I put out a video last night and I promised I would show the full hearing today. So we're gonna start in Colorado and then we're gonna move to Colorado. We got two courts today, they're both in Colorado. First one's a brand new judge. So if you didn't see the video that I put out last night, here it is, the long version, the whole thing.
Yeah, I've never seen it.
For which one?
It was not something I'd ever seen before, and everybody who I'd shown it to was good.
Okay. Thank you.
But they get blood under that provision. You know, there's, I'd like to get it resolved, but let's at least finish it first. Yeah.
Are we ready?
Mr. V Hill, yes, we are ready.
25 CR 1258 People versus Allison V Hill. Good morning, Mr. V Hill. Who's present, please?
JC Baber for the people, and the victims are present online.
Okay.
And Jacob Goldstein for Mr. V Hill, who is present to my right, and his parents are also in the gallery today.
All right. We are set for arraignment today. I had the paperwork for the plea agreement forwarded to me. Let me look at it quickly. Has it been uploaded?
Yes, I think I just uploaded it.
This agreement states that Mr. V Hill will plead guilty to count 2, burglary, a class 5 felony. There's a stipulated 3 years to the Department of Correction with restitution reserved, and count 1 will be dismissed. Is this a complete agreement?
It is, Your Honor.
All right. And is this your understanding of the agreement, Mr. V Hill?
Yes, it is.
Is this how you'd like to proceed today?
Yes, it is.
Have you discussed this agreement with your attorney?
Yeah,
Are you satisfied with his representation of you?
I am.
All right, give me 1 second. All right, tell me your full name.
Allison V. Hill, C3?
Are you the defendant charged in this case?
Yeah,
How old are you?
36.
How far have you gone through school?
Some college.
Do you read, speak, and understand the English language?
Yeah.
Are you thinking clearly today?
Yeah,
Have you consumed any prescription medications, drugs, or alcohol in the last 24 hours?
my normal medication. Yeah.
Is it affecting your ability to think clearly today?
No.
Okay. Do you suffer from any mental or emotional condition that would make it difficult for you to understand what's happening today?
Not that would make it difficult for me to understand today.
Okay. Are you a member of the United States Armed Forces or a veteran?
No.
Just 1 second. Is this an original count?
I believe it's an.
No, it's an added count.
Has that been uploaded?
Yes, it should be in pending.
Okay.
But I can also read off the motion if
I
that's easier.
just pulled it up. Thank you. So the count 2 alleges that on March 3rd of 2025, that you, Allison C. V. Hill III, unlawfully, feloniously, and knowingly broke an entrance into, entered, or remained unlawfully after a lawful or unlawful entry in the building of Stephanie De Aguero and Mariah Rucker located at 160 South Elliott Street in Denver with the intent to commit the crime of burglary in violation of 18-4-2031 and 2D of the Colorado Revised Statutes. That's a class 5 felony. With respect to that count, do you plead guilty or not guilty?
I'm so sorry. I'll take it back if I could. I'll plead guilty.
Okay. Before I accept your plea, I need to make sure you understand your rights in this case. You have the right to be represented by an attorney at all stages of a criminal proceeding, so not just this proceeding today, but all proceedings, including a trial. If you're indigent and you cannot afford an attorney, one would be appointed to you at no cost. You also have the right to a speedy and public trial that must be held within 6 months of the entry of your not guilty plea. and you have the right to have the charges proven against you before you can be convicted of them. So at trial, you'd be presumed innocent. You would not have to prove anything. The district attorney would have to prove your guilt by proving all of the elements of the crime charged beyond a reasonable doubt to all 12 jurors, because any verdict must be unanimous. At trial, you'd have personal rights, including the right to testify and the right to not testify. That decision, whether or not to testify, would be your decision. You'd have the right to call witnesses and present evidence, including asking the court to issue subpoenas for witnesses and documents. And you'd have the right to confront any witnesses called by the district attorney who may testify against you and ask questions of those witnesses. If you went to trial and you were convicted, you'd have the right to appeal to a higher court. Do you understand these rights?
Yeah,
Do you understand by pleading guilty, you give up these rights?
I do.
Do you understand there will be no trial in this case given your plea?
Yes, ma'am.
All right. I have the plea paperwork that's been filed that goes over this plea agreement as well as your rights. That paperwork has the initials, electronic initials AV throughout the document, and on the back page, there's an electronic signature above your name. Did you initial and sign that document?
Yeah,
There's also a document entitled Elements that goes over the elements of the charge you're pleading guilty to. Is that your signature on that document? By signing these documents, does that mean you've read them and understood them and had an opportunity to ask your attorney questions about them?
yes,
And in signing these documents, you understand you're giving up any defense that you have to these charges?
yes,
Do you understand that you're subjecting yourself to the penalties provided by law for the offense you pled guilty to?
yeah, I deserve it.
What's that?
So yeah, I deserve it.
All right. And you understand the possible penalty? I'm sorry, one second. The possible penalty in this case, is it in the presumptive range?
Aggravated range
Okay.
should be a 2 to 6.
All right. So it's 2 to 6 years in the Department of Corrections is the possible penalty, with a 2 years of mandatory parole and a $1,000 to a $100,000 fine. Has your attorney advised you that if you're not a United States citizen, that immigration issues could arise from a guilty plea?
Yeah.
Other than this agreement that we've discussed today, has there been any other promise made to get you to plead guilty?
No.
Is anyone forcing you or pressuring you in any way?
No.
Is this your own free and voluntary decision?
Absolutely.
Okay. Factual basis?
We would waive.
All right. And you still wish to plead guilty today?
Yes.
All right, Mr. Vigil, I'll accept your plea. I'll find that it's a knowing voluntary. It is knowing voluntary and intelligently entered. Judgment of conviction enters on count 2. Count 1 is dismissed. Are we moving to immediate sentencing?
Believe so.
Yes, Your Honor.
Okay. Go ahead, Mr. Goldstein.
Your Honor, this was a really hard decision to accept this plea. And I want to be clear that when I say accept a plea, I don't say accept responsibility. He's been accepting responsibility since the beginning of the case. We had a bond argument in front of Your Honor, where really over the advice of counsel, he took the time to apologize to the victims. He is someone who is incredibly remorseful, of course. That doesn't even reach the level of where he is at. These two women had no stake in the game. They were innocent. He did not mean to cause them harm. He is so apologetic and sorry to them. Obviously, the trauma that they experienced is something that they're going to have to work through. But to the extent that it means anything to them, he really has been wanting to take responsibility since the beginning. He's been so apologetic. He's recognized the fear that was caused. The reason this plea was hard was because he needs mental health support and services. The reality is he's not going to get what he needs through this plea. But there really wasn't anything else to do. The original offer that we had been going back and forth on was essentially a stipulation to community corrections. He is not probation eligible, and so there was a cap of community corrections offer. I believe that is the offer that probably is the right offer, but because of parole, he would have been rejected. So he would have been sentenced to community corrections. I think I may have misstated. I think it was an open sentence, but I believe that based on the mental health, I think there was a good argument that the court would have sentenced him to community corrections. But realistically, he couldn't serve a community correction sentence because of parole. And I understand why Ms. Baby was not willing to agree.
I just hate when they use my old crimes against me and my new crimes. I hate that.
To a community-based sentence based on everything, but I do think that that was right. Right before, not right before this happened, he had served a Department of Corrections sentence. And right before that Department of Corrections sentence, he actually got mental health diagnoses and was prescribed Wellbutrin for the first time, which was a really important thing to happen, except he was immediately taken to Department of Corrections, and his experience was that the Department of Corrections will not provide him with Wellbutrin. So he was unmedicated for the full time he was in Department of Corrections. When he got out, he has an incredibly supportive family who was here. But when he got out, he was dealing with the undiagnosed mental, or the unregulated mental.
Yes, Wellbutrin. They use Wellbutrin for mental health, but no, it's not like no. People don't do things like this because they're not on Wellbutrin. Wellbutrin's, it's not strong enough.
Mental health conditions,
Mental health
and
medicine.
was struggling with substance abuse and homelessness. And that combination was incredibly difficult. His mom sent me text messages from her where she is texting the parole officer, begging the parole officer to provide more help for her son. And most of those text messages went unanswered, and they didn't give him the help that he needed. He had a mental health crisis when this case happened, and he went back to his childhood home. It's a home he grew up in. When the police arrive, Mr. Vigil is sitting on the steps of the home, and they say to him, what are you doing? And he's like, well, what do you mean? I'm at my home. He lists out the address. They're like, are you expecting somebody? And what proceeds is almost gibberish. It's not really coherent, but he's kind of saying he's waiting for people. I think that there would have been an argument at a trial for this not being a burglary. He was not there to hurt anyone. He wasn't there to steal. He wasn't there to commit any crime per se. I think really it's a trespass and a criminal.
Yo, this lawyer is just lying on all you listening. Don't believe him.
Mischief. But that doesn't change what the heart of the issue was, and his want to accept responsibility and resolve this matter. So ultimately, that isn't as important. I think this is unfortunately a somewhat of a tragic situation for Mr. Vigil from my standpoint, because he is one of the sweetest clients I have, and he has been regulated and medicated since he's been in custody over 150 days. And he is this calm, sweet person who is incredibly remorseful about what happened, wants to make it right. He will spend time just crying and sharing emotion with me. And I gave him a hug yesterday before we ended our meeting, and I really feel for him. But I also understand that these two women were incredibly scared by the situation, and it's just really it's unfortunate all around. And sometimes this system is not necessarily properly set up to help people, particularly when they're in a circumstance where they've had criminal history, where they've served time in Department of Corrections. So I know that he is ready to finish his time, to get his time served, and really just focus on his mental health. He had gotten himself into a sober living facility. We weren't able to get him out of custody. The bond was not something he could post. So he hasn't been able to get to that. But I know he intends to focus on his sobriety, on his mental health, with the time that I'll have in the Department of Corrections, and ultimately continue that effort after. Hold
on. It was mental health a minute ago. Now it's drugs? Is that what did it? He did this because of drugs now? First it was a lack of drugs. Then it was other drugs?
I do think that the court should accept this resolution. I think it is appropriate. It's a tough one, but I think it makes sense as these victims were harmed. And Mr. Vigil does have a criminal history, but I do want the court to recognize the mental health struggles that he's had. And again, I just would share for the victims that he is incredibly, incredibly sorry and remorseful.
Thank you, Mr. Goldstein. Ms. Paper?
Thank you, Your Honor. I'll first let the victims, Maya and Stephanie, speak. They are present virtually.
Okay.
They struggle here.
If you'd
so
like
I'm
to
gonna
go ahead
go
and
they'd like to see here, but
Hold on. Yeah.
what happened. But I believe this agreement is appropriate given Mr. Vihill's criminal history and the fact that he was on parole at the time of this offense. I'll note that the victims will speak to how this impacted them and what they'd like to see here, but we spoke extensively about this case and how to resolve this case. Mr. Vihill did break the glass door to their home and in the middle of the night and stand over them in their bedroom. And I think that was really the heart of what makes this so scary as a young woman in their home. And the act of breaking that glass kind of it scares people into knowing that whoever has entered their home is not afraid of violence. And I think that's really what the focus has been on here. And in the light of Mr. Vihill's actions in this case and his criminal history, I'd ask the court to accept this agreement, and I will hand it over to the victims.
And I forgot to note, I'm 151 days of credit.
Thank you.
They can maybe try calling in?
There's a WebEx issue with the microphones, so let me.
Hello, can you hear us? Sorry
Yep.
about that.
Okay, we can hear you. It says Maya, are you both there?
Yeah, it's both of us. It's Maya and Stephanie.
Okay,
Good afternoon, Your Honor.
Or like I like to call them Mad Maya and Stephanie. Mad, which I would be too.
good afternoon. I do remember your statements last time. I'm glad you could be here today. What would you like me to know?
I just wanted to say that I really don't think it was a simple mistake or a moment of poor judgment. I heard what he had to say, and I do think it was a violent burglary. He grabbed a river rock from our backyard, shattered our glass door. Like we heard heavy footsteps, and in one of our, in our safe place. And as we called 911, he kicked open our bedroom door, and he was just staring at us, holding a bag and wearing a hoodie. And we were completely terrified. And just moments later, when we're trying to get to a safe space, like in our own home, he's in the, on our doorstep. And I think, and he actually did take something from our house as well. He took our vape, and we have it on
Burglary.
camera, on Ring. So I think he was, I mean, I don't know what his intentions were, but we're psychologically scarred. I mean, there's no excuses for, what he did. And I definitely, understand the court's compassion for, people who are battling mental health, but, I don't think it should be compassionate enough to, endanger innocent people like Steph and I, and holding him accountable and making sure, he gets a treatment. I think there's a balance for both public safety and also his needs. And I just wanted to, request, like, we don't want any further harm to happen. I know he grew up in the home, like it's not his home. And now there's tenants in there, and I respectfully ask the court, if there could be strict no contact, no approach orders, and also just ensure that that the sentence reflects the true severity of the crime that he committed. I don't know, Steph, if you want to add anything to that.
Yeah, I understand like both sides of this situation. But at the end of the day, Mr. Vihill has a criminal record. He was on parole when he broke into our home, and that just kind of shows that he's constantly out here committing crimes, and it's just something that, you know, we've taken into consideration as we've been working with our representation, and I believe the plea deal that's on the table is something that sufficiently accounts for the crime that we're talking about today.
All right, thank you. I appreciate you being here today. And it's important for me to understand how this impacted you. Mr. Vigil, you have the right to make a statement. You don't have to make a statement, but is there anything you'd like to say?
Yeah, absolutely. What I did was unforgivable. So the calmness that they're showing and the patience that they're showing, I appreciate. You know, like I have a daughter, which I'm not making an excuse for it. I'm saying if that happened to a woman in my family or even to myself, like I don't know how I would deal with that. Like that's traumatizing for life. You know, how do you go to bed after that and not be scared that could happen again? Not from me, not just from me, but from somebody else. And like I was thinking about from the other side, like if that happened to my daughter, like I don't care what excuse it was for mental health. Like bro, you're no, that's unforgivable. So I appreciate. I hope that God could put forgiveness in their heart and heal them. I got to deal with my own stuff. My own stuff is not an excuse for what happened. No matter how bad my mental health gets or what I've been through, they should never have to experience that. My stuff should never have to carry over to anybody else. So yeah, the deal is glad that they said it's fitting. It's leniatum. I'm so sorry. And it is unforgivable. So I'm like asking for forgiveness, but like don't expect it. My bad. I don't know what I can say. Listen, I'm not crying till I don't feel sorry for me. You know what I mean? Like it's just, I don't know how to express it. I believe in God. I'm gonna have to answer this to God one day, and like standing in front of God on Judgment Day. Like I have no excuse for this. I have no excuse. So I hope I can pay penalty in this life and be forgiven for the next one. And I hope I could do better and not mess up anymore and not do stupid things and take care of not only myself, but like just sorry. I need to do better and I should have realized. And I'm sorry. I don't know. I wish I had the words for it, but it's unforgivable. I'm sorry. May God have mercy, please, and y'all have mercy on me too, please. I'm sorry to the people of Colorado. I'm sorry to these women. I'm sorry to y'all, Your Honor. I'm sorry to my parents, my family. I apologize. Thank you for the time.
All right, thank you, Mr. Vigil. I appreciate you taking accountability. I don't hear many people addressing the victims and the impact it's had on them as much as you have today. So I appreciate you see the impact that you've had here.
Yes, he's a great guy. He's a great guy for addressing the victims. So I thought I heard the prosecutor and the defense attorney say he had a bat in his hand, but it sounded like Maya, the victim Maya, who, you know, was terrified, said bag. So if he had a bag, that was clearly for burglary. If he had a bat, he did.
You know, the details of this case are concerning that from the victim's perspective that you broke through their back door in the middle of the night with a rock and you were holding a bat, wearing a hoodie.
She said bat.
Certainly
Clearly said bat. The victim said bag, though.
that would terrify to your point, any person, but especially women. I did note in your the bond advisement report that you have at least 5 prior felonies. I also recognize that this was likely the result of some mental health issues. I don't disagree with your attorney that our system just lacks the resources we need. because that's really the goal, is to get treatment and to appropriately punish so that these things don't happen again. So when I look at the sentencing factors in 18-1-102.5, you know, when we're talking about punishing a convicted offender by imposing a sentence that he deserves in relation to the seriousness of the offense, I think that the plea agreement is appropriate in that regard. The offense was seriousness, and this is contemplating 3 years in the Department of Corrections. I've considered all of the factors, but I hope that also this provides an effective
much does
deterrent
he?
for others likely to commit similar offenses, and is, I think, to the best that we can, it addresses your individual characteristics, because probation wouldn't be appropriate here, and it sounds like community corrections wouldn't be an option. And so, you know, hopefully you can get some treatment in the Department of Corrections. And I think it promotes acceptance of responsibility and accountability by offenders, and hopefully will provide restoration and healing for Stephanie and Maya in this case, and will attempt to reduce recidivism. So I think this is an appropriate plea agreement when
No,
considering the
Fuzzy,
case
he's
file
not.
and the sentencing factors. I'll sentence you to 3 years in the Department of Corrections with 2 years of mandatory parole. I'll give you credit for 151 days. Do you have minor children, Mr. Vigil?
Yeah.
Are any of them subject to a dependency and neglect action? Okay. Do you have a record on fees and costs?
Your Honor, I would just note that he has been in custody this entire time, that he will be serving a term of Department of Correction. So I would ask the court to waive. I don't know if Ms. Baber made the record, but we did.
Plenty.
I was on notice of it. There will be a restitution request to follow. They just start gathering that information now. So in light of all of that, I'd ask the court to waive any fees and fines.
All right, I'll waive the fees, the waivable fees and costs with the exception of the victim's assistance and victim's compensation fees. I'll leave restitution open for 63 days. Any objection needs to be filed within 14 days, otherwise the requested amount will be ordered. Is there anything else on our end? Anything else from the parties? All right, Mr. Vigil, I wish you the best of luck.
Working children, it builds character. They don't sit around on their iPads all day. I say 7-year-olds, go to work, go to school, go to work, then school, then work. That's how life should be.
Luck. Same for Stephanie and Maya. All right, good luck to you.
All right.
Do you guys remember this? In Law Talk with Mike, hold on. All right, I'm just going to start it there. Can you see that? You are at the 36th District Court. You are at the 36th District Court. There you are at the 36th District Court. I loved this cup when I got it. It was Lenise Bryant, Judge Bryant. Do you know what I'm talking about? Or did this happen so long ago that no one knows what I'm talking about anymore? Anyway, I love this cup. I always love this cup. Makes me smile. I don't know if I want to play any more of her. I'll play a little bit more. And then we'll go to this one. We're going to go to this one. It just makes me smile, man. I don't know why. I love this cup. So yesterday was mental health docket.
And that Mr. McPherson was all hyped up.
Okay. Just so you know.
And what?
I got it from Law Talk with Mike's merch a couple years ago. This was a trial. You know how I said Judge Eric hasn't streamed in a couple of days? He did us dirty, you guys. He did us dirty. He had a murder trial going on. And he streamed today for the first time, and it was closing arguments. So I got closing arguments, which I thought she did great. Really great. And then I thought he did great. Really great. So I don't know if he's a murderer or not. It was a gang trial. Bloods, I think. I don't know. Anyway, so then gives him the jury instructions, and I wait, and he took it off live, so I have no idea if verdict came in or not. And it was fine, though, because Blanco's on, so we're going to go to Blanco.
Started now instead of October. And that's for people so that you're not stuck for as long in getting an eval and everything else. So certain people will qualify for a special program and you might be one of the first people. So yeah, it's really cool. You'll be a pioneer. So let me get you a new court date. 2 weeks is the docket on 14. Give me 1 second. I don't have a comp docket currently set for that afternoon, Miss.
I'm going to move it to the next person. Since we missed half of all of this one. There we go.
All right, Floyd Allard, 25M295. Mr. Allard is present before the court and he's out of custody. And Ms. Hewitt is here as counsel. Hello, how are you? Both of you, yeah.
Doing good, Your Honor.
Good, good. I mean, I wanted to make comment too, because I was reading this yesterday and I'm like, man, look at how far you've come since March, right? I mean, how well things are going. I'm super proud of all of your work and your effort. And then when I went to the staffing today, pretrial services says you're doing great with them too. And that's not on this report, but you're just doing such a great job. Good job, Mr. Allard. You are working very hard and it shows when I read through all of this. Let me see if there's any objection to the finding.
Your Honor, I need a little more time with him with regards to that. I was not able to review it with him prior to a few minutes ago, and I just would like to have some more time.
What's your schedule like in the afternoons now, like right now?
I'm fine until, and on Thursdays, I'm very fine. I would like to say like that 21st day, if possible.
But the problem is the only time
I don't listen to people who have a degree. A class or two is the perfect sweet spot for psychology. I'll listen to those people.
on the 21st was really late in the day at 4:30, and I didn't know if that would work for you.
Yeah, that'll be fine. Sydney's old enough to sit at home now.
Oh my gosh, we're all getting old.
I know we are.
Okay, the 21st of August at 4:30, we'll come back for a, I'll just say potential disposition and adopting the findings potentially.
No, that would be great because we are actually going to do a dual, try to maybe have a disposition if we can.
I will do my best to help you. These are hairy dockets, so just in case. All right, sounds good. We'll see you then. Keep up your good work. I hope you're proud of yourself.
Your Honor, I got a few questions for you.
Okay, are they nice?
Yes, they are.
All right, okay.
First of all, I would like to know the names of the district attorneys, the man that handled last time. I heard a nickname Axe.
Yeah, his name is Mr. Oxmacher.
Oxmacher, yeah, Axe.
Like, yeah, so it's.
If I could get like maybe his card and the other DAs that stepping in today, his card.
Mr.
Excuse me. Just talking a little fast here.
That's okay.
I'm a little bit on caffeine here. I'm also wondering when I might be able to receive the video coverage of Mr. Carrion pointing a gun at me from inside the 7-Eleven at US Highway 34, US Highway 287 and Harvard. I've requested from Fort Collins PD at least 5 times. I called them and they have not even issued a call back to me. I am also wondering when I can file my attorney here.
Judge, God gave you 2 ears and 1 mouth. That means you need to listen twice as much as you talk. Let him go. I want to hear what he's saying. Put your finger down. Put that finger down.
And get my copy of my
Good girl.
my competency exam. I'm going to represent myself or have the United States Air Force represent me.
Okay, so just a second. First of all, we will get you, Mr. Gibb has a card in that office is where both of them are working.
Thank you.
If you meet with them, you need to know that anything you say to them can be used against you. They are not your liars. Okay, well, I need to advise you.
Thank you. Thank you.
Second, when you go to the police department to make a request, the reason your lawyer goes to the DA's office to make a request is the DA has an obligation to provide information And so they want to make a record of it being requested in case there's something that needs to take action otherwise. So you should meet and speak. I know, I'll get to the third part. You need to meet and speak with Ms. Hewitt about what would be the best strategy for requesting the video you're asking for. And then finally, once you're deemed competent to proceed and she can share a copy of your report with you, once you're deemed competent, then if you want to represent yourself, you may do so. But I would encourage you from now till the 21st, talk with Ms. Hewitt. She's a good attorney. Let her help you understand, because your case has just been on hold with the competency piece and it's getting ready to potentially resume.
Your Honor, I have a very high IQ. I'm very intelligent. I'm very smart. I'd like to review my competency exam,
Beck, we
findings
love
by
you.
myself. I've heard that I've been found competent. I don't think I need to discuss any further information with any attorney or other outside source.
Well, but if they've made an offer, she wants to relay it to you. She wants to provide you information. If we need to order a video and they're not providing it, she wants to advise you what your options are.
And I am privileged to that video also. That is my right. I can pay cash for that video.
Right. So I'll let her work with you on that.
And I did not receive any consultation, or I should not say consultation, but callbacks.
Mr.
For
Edler,
speeding.
I love that you're telling me you're intelligent.
They're negligent.
There are a lot of
It's negligent.
people that want to have lawyers to
Yeah.
navigate this because they know I'm really smart.
I got an
and I'm
$800
not a lawyer.
got an $850,000 scholarship to study law at Harvard.
Okay. So
That's freaking amazing, guys. Did you hear that?
work with Ms. Hewitt, then you know the benefit of why going to law school is important.
Can you answer my question? I think you already did, but when can I fire her?
So if you're found competent, then you can. We haven't adopted the findings. I'll see you on the,
Thank you.
I'll see you on the
Thank you.
21st at
Thank you.
4:30. You're welcome. See you then. Thank you.
Thank you.
Okay. And
Don't
Lynn
talk to her.
Mooney, 24T835, is present before the court and she's out of custody. Mr. Iddings is present as her counsel. Hi. Good afternoon. All right, so you're doing great with pretrial services. Keep that up so that you can stay on that bond. They were telling me what a great job you were doing, so great. And prosecution, do you need me to order this evaluation? Okay.
I still remember the first case I got of hers, and it wasn't one of the inmates that freaked out in her courtroom. It was the father, and he freaked out. I remember Mr. Thomas. His name is Mr. Thomas. I know because she said it 100 times. Mr. Thomas, you are the problem. You are the problem. You are why your son cannot get the treatment that he needs. You, sir, are the problem.
Yes, Your Honor, here we'll be requesting that evaluation and to appoint Bridges as well.
Court at this time is going to appoint Bridges. You probably heard me explain this 2 times. You're out of custody, but if there's any resources or things they can do to help you or appointments and all this, they're here to just help support people. So I'll appoint them so that they can meet with you. If you have questions, they can help navigate this. They're not lawyers. Mr. Iddings is your lawyer. And the evaluation is the same as I explained to some of the other folks. If you're accused of a crime, I do have to make sure that you can defend yourself against accusation. That's all.
Milton Hershey. He made Hershey's chocolate, I think. Oh, shit. I was wrong. It's mental health. I was close.
The evaluation is helping me understand. So I will order the evaluation. Yours will be out of custody. So that means you don't have to go into a hospital, go into a jail. You'll just make an appointment to have the eval. It'll be a little while before you have the evaluation because they're pretty backed up. And if you want to talk to Mr. Iddings before the evaluation, you go ahead and do that. Just help me get the evaluation done. If you need extra support, I'll give it to you. If you don't need it, then the case will resume where it left off, okay?
Okay.
Yeah.
That's a good question.
Of course.
I live on my own. I have a service dog And so are they going to be coming into my apartment, just evaluating?
You know, the Bridges people are very sensitive, and so if you explain to them what's going on, you can just talk with them. They're very sensitive. The doctor won't come to your home. Your appointment usually will be either virtual or here in the courthouse. And if you have a service dog and you want to check in on our first floor with administration so that you can show that this is actually a legitimate service dog, your service dog can accompany you here to the courthouse as well, okay? You're welcome. Anything else?
What if it's an emotional support pony? Remember them guys, the emotional support ponies? We saw them.
Okay, let me get you a new date to come back. And our out of custody evaluations are pretty far out there. Isaac, my next one is October 22nd. Is it likely that she might have a sooner one if I don't give her one of mine?
Doing some math that might stop you bet, doctor, so it's right up the
Okay.
May I ask one more question?
Yes, you may.
If I'm found competent, then it's just gonna resume as normal with
Yep.
the judge that I was
Yes.
initially working with.
Sometimes if the lawyers have an agreement, they'll ask if I'll just keep and hear the case. So if there's an agreement, I won't make it take longer for you because you might want to just get this over with. But yes, in theory, it just resumes because you might want to set a trial. You might want to keep negotiating. And so it'll resume. But right now it's just kind of on pause to make sure that we're being careful and protective and doing a good job. Yeah. Of course. And so I think what I'm going to do is if it's that close to one another, I'm going to gamble that you might get a doctor's appointment before the one that I have available. And I'll just set you in just to check in with you. Your eval probably won't be done by the time we're checking in. I just want to see how things are going. So let's come back together on September the 18th and at 4 o'clock in the afternoon. Are you able to accept that, Mr. Iddings? Are you with me on that day?
Yep.
Okay.
I can accept.
September 18th at 4. I just want to see how things are going. Do you have any questions?
No, I apologize for getting emotional.
No, no need to apologize. Sometimes I get emotional up here, particularly if somebody gets emotional over there. So yeah, you're okay. It's stressful, but you'll get through it. Most people do. Okay. All right.
There's my card. Thank you.
Nice to meet you. Casey Peterson, 25M938. Present before the court, out of custody at this time with Mr. Iddings as counsel. Did you get your court dates confused?
Yes.
That's what I figured happened. I waited for you till the very end. No, I understand. So here's the thing. So in 25 CR 984, he has an active warrant, but that case is a little complicated, Mr. Iddings, because his cosigner wanted off the cosign bond. And so he was probably going into custody because of that. And I don't know if he has another plan for a cosigner lined up. And I'm not sure if the DA thinks that that bond is okay.
I'm not sure. I don't think I have. So my girlfriend left me. That's why this all started. She said she was going to get cigarettes during the back
Talk about things.
So I don't really have anyone. I don't. Me and my father are estranged right now. There's just
1 second, Casey.
yeah.
One second. I said 25 CR 984. Okay, 1 second. It's actually 974. It's 974. Okay, so let's back up. Let's talk about things we have some control over and what we don't. So is this a VRA case prosecution? Okay, so I can visit some of these issues. I'm recalling this case. So your cosigner was Michael Huston or Houston. He does not want to be on your bond. So you're going to go into custody. However, I'm going to quash your warrant for your failure to appear yesterday. And I'm going to release the bond to Mr. Houston. And I had a $300 cash bond on there, but you don't have to post a $300 cash bond. You do need a cosigner because there's a $5,000 cosign PR bond. So you do have to have a cosigner. So Mr. Innings, I'm just basically going to undo his failure to appear for yesterday. But he's going to go into custody. He needs to find a new cosigner. Okay. Yes.
So, my house was broken into recently. They stole my phone, my wallet, my guitar, a bunch of stuff, but I have no phone, so I have no contact information to call anyone. My father says he won't sign for me anymore. I'm not sure why. My little brother's out on bond, he can't sign for me. My older brother's out of state, he won't be able to sign for me.
So do you want me to leave it as 300 cash?
Is there any way I can get a PR?
It's either going to be a cosign PR or it's going to be a 300 cash. So I was going to undo. Okay, then I'll leave it at the cosign and I'll quash that warrant, Mr. Iddings, and let's get, the problem now I'm having is the misdemeanor case, petty offense, I should say. I'm trying to figure out if you are wanting both of these cases to have evals ordered in them, because one is here and one's on my regular 3A docket. 1 second.
I would like both cases
Brought here.
and evals ordered as to both of them and Bridges appointed as to both of them.
Your Honor, the people would agree with that.
Okay, so I'm going to do that. And Casey, I'm going to order the evaluation to make sure that you're able to adequately help defend yourself in court. I'll order it in both your cases. If you want to talk to Mr. Iddings before you do the eval, that's fine. You've been through this process. Cooperate. I want to get a good idea of whether you're able to aid in your own defense. And remember, they're going to produce a report. It's not a private meeting. Now, I'm going to appoint Bridges in both cases. You've already worked with Bridges. You know how that works. Mr. Iddings, the last thing, he had Ms. Hewitt helping him before. And I think Mr. Goldstein was going to look into whether or not there's still a need for an ADC. So if you look into it and think that there is a need, he does work well with Ms. Hewitt, and that maybe could be an option too. Go ahead.
Is it possible I could speak to my father for a moment before I go to custody?
No, but.
Just to get a couple phone numbers from him.
Okay. So I'm going to have you go into custody. Mr. Iddings might be able to help you, but no, you can't go back there. This is kind of a one direction, like a river.
Yeah.
So you're going to go through these doors, but the cosign bond will be back where it needs to be. Mr. Iddings, I'm going to order it in custody, evaluation at this point. Is there anything else?
We need a next court date.
Yes, you do. I'm going to set it for September the 11th. Both cases will be brought back at 2:30 and 2:30 September 11th. These are not VRA. If you have an evaluation sooner, please let us know.
September 11th.
At 2:30.
At 2:30.
Yes, sir.
Thank you.
You're welcome. I am releasing the cosigner off that bond. I denied their request, but
What is the Biltmore?
they don't have to be on
What
the
is
bond
it?
anymore.
Sounds like a hotel, motel, Holiday Inn.
Oh, do we have? Okay, thank you. Kent Brown, 25M 1004, 25M 333. Our interpreter matter is an in custody matter. So once Mr. Lopez is brought upstairs, I will call it in custody matter. Yeah. But right now we have Mr. Brown in front of us. He's in custody and he is present with Ms. Lowry as his counsel. And yeah, you're doing a great job. That mat is working well for you. You're taking your medication management at the jail is working really well for you. Yeah.
Thank you.
Yeah, and so I think that's great.
Literally, all you have to do with this judge is take your meds. Listen, you can miss every court hearing. You can commit a new crime. You take your meds, and she is just pleased.
Listen, I love you too.
Okay, so you are somebody who engages in behavioral health, mental health treatment. Okay, I was going to tell you just be open-minded if you think something could be beneficial there. For fun, when I was reading your report, I just asked my little electronic Google, how many people would benefit from support for like mental health support? It said 75% of the population would benefit. And I wasn't sure if you were open to it, but it sounds like you are. So yeah, not 100, but well, the professionals on our team were debating whether it was too high or too low. So you vote 100 is what it sounds like. Okay, I'm going to quote you later today to everybody else who doesn't want treatment. Okay, all right. Well, Mr. Brown, you're doing a great job, and I got your eval back. Ms. Lowry, can I adopt the finding?
Yes, Your Honor, I do not believe a second evaluation would yield a different result.
Okay.
But I do have some comments about the direction the case goes next.
Sure. What are your thoughts?
So Mr. Brown, I calculate in 25M333 that he has 107 days of credit for time served on this class 2 misdemeanor, which has a maximum of 120-day sentence.
Okay.
That was a verbal harassment that happened in the community. He has obviously a very different version of events, but that being said, he's served almost the maximum sentence on that case. 25M1004 alleges that he damaged a tablet in the jail. That happened on May 4th, so he's eligible for 89 days of credit towards that M2 as well. He would like to plead guilty today to these charges, and he would like the court to give him credit for time served.
But he doesn't have an agreement.
We reached out to Mr. Achenbacher. He has been in trial, and so their position is that the case returned to the division for us to negotiate with people there. Mr. Brown is hoping that, just given the amount of time that he has served and how well he's done while he's in custody, the court might sentence him to time served today, but no, he has no agreement.
Mr. Brown, if you don't have an agreement, then I have to advise you on a class 2 misdemeanor. On each of these cases, you could serve up to 120 days. I can't promise you what the outcome will be because I haven't heard the DA's perspective if they're agreeable. So I have two options. I don't know if anyone has spoken to Mr. Gibb to see if he has an. You what?
I was just hoping to squash the whole thing, get my mind going.
Yeah, I mean, I guess the question is if we set it back into division, I guess here's a positive thing. I have a court date pretty quickly to come back to court, Ms. Lowry, because they have court available on Tuesday.
Yeah. Okay.
You want to do that?
I mean,
see if you can work out a guarantee, because 89 to 120 is still a little bit more days of jail, you know what I mean? So it might be better not to take a risk today. It's up to you.
I was thinking, I mean, I was a yelling argument 50 yards apart, you know, and then I walked away and next thing you know, I'm doing 120 days in jail. And he doesn't.
Well, maybe not.
I can't beat the cell phone, so I mean, I don't get a say so. I
don't
get time.
Sounds like you've thought through a lot of this and talked to your lawyer about it. Why don't I reset you? Can I adopt the finding then?
yes, Your Honor.
I'll adopt that you are competent to proceed. I'm going to reset you for Tuesday at 10:30 in the morning in front of Judge Acton. Let's see if you all can reach an agreement. That way you know for sure, Mr. Brown, how many days instead of being up to 120, okay? It might be worth it for the few extra days just to have a guarantee, okay?
Well, the time that I dropped and in fact, I got pissed, so I slammed it again because it wasn't getting charged.
You have the right, you have the right to take that shot. So you'll know that before.
Thank you. Let's see if maybe Mr. Lopez. In the meantime, I'd like to just take a moment, the Lindsay Stuckey Matty 24 CR273. I know Mr. Watson is here as her counsel. So Mr. Watson, I excused the Attorney General from appearance today because she was moved to the state hospital yesterday. And I didn't think that there was any fruit to be gained to bring them all the way up here for this case today. So she's there now, and she's not logged in because I don't think they had enough notice to be here virtually. So I don't have any other update other than I think she's probably where she needed to be for a long time. And I'm happy to reset us so we have a little extra time for her to get some treatment before we come back. Do you have any additional information you want to provide an update on?
Thank you, Your Honor. Ms. Stuckey did call me from the facility and I did speak with her and she sounded like she's doing a lot better.
Mm-hmm.
So we're on the right track as best we can be, but other than that, I don't have anything for the court.
Let's set this on October the 23rd if you're available in the afternoon.
Shockingly, I am, Your Honor.
You are, okay.
It's
And
my very busy trial month, so I'm glad we could find a date. That was October 23rd.
yes, well, let's set this in perhaps at 2:30. Prosecution, could you do a video writ from Simhip in case she's still there? And if she's returned to us sooner than that, I'll see you sooner than that. Thank you both sides for hard work to help someone get to the appropriate level of care. That was a journey.
An educational one.
I'm glad it was educational for you, stressful for me. I don't know what Mr. Osmacher would say. All right, thank you. And then Timothy Vester, 24 CR 5230, 24 CR 1160. Mr. Vester is present before the court and he is in our virtual courtroom out of custody. And hi, Mr. Vester.
Hi, how you doing?
Good, how are you?
Doing really good.
Good. Mr. Vester, your lawyer, Ms. Lowry, is here in the courtroom. Ms. Lowry, I need your help. Your client is doing hopefully well at Stout Street, but Stout Street doesn't communicate with our team, which means I may not allow people to go to Stout Street if we're not going to have open communication. I don't know how to fix that. And I'm wondering, I don't know if a release has been submitted or
I don't
not,
think
from
that
Mr.
it has. I
Vester.
think we might need an ROI here. We have to do an ROI to get release any information to South Street.
Okay, and so if it's that simple, but Ms. Lowry, just so we can build a bridge, could you help us? And I think there's one other person on our docket today that South Street could be a potential option. It's like, I do not want to not have options, but we can't have someone go and then not know what they're doing while they're there. So Mr. Vester, how are things going from your perspective?
Doing good. I started dual diagnostic therapy this week. I started my first class. I'm also working maintenance here in the facility as my job. I start class. My next class would be inner child. So it's going good. I'm about to get out of orientation phase.
Okay. All right, so you've hit the ground running and I'm glad to hear that. And you're not in orange.
Did you break anything? Are you limping? Because my mods, a lot of my mods have issues walking over the past couple months because they've been injured. They can't walk.
And that's nice for you. And you are getting one more opportunity here, so that's great. Did you get your new Colorado ID?
They don't get that. We have Stout Street IDs.
Oh, okay. I thought you were trying to get a new Colorado ID.
I was at first, but then here they said it's wait until we get into our 6th phase.
Okay.
We have 5 phases.
Okay, no problem. All right, well, I think what we want to do is we want to make sure that a restoration provider has been provided. That stuff has not all lined up yet. So I might come back in a few weeks just to see, and if we could get a release of information or something, that would be great. Ms. Lowry.
Yes, Your Honor, I can work on all of that. Historically, Stout Street has been a very difficult program that have not hesitated to discharge people if there were any sobriety or behavioral issues. And so the fact that Tim is here and looks healthy, I take as a very good sign that it's going well. I did communicate to be able to share the log and information to his case manager, but I'll definitely follow up on with releases and all of that. I appreciate the work that Lauren did to pivot and help Tim and Tim's motivation to get into a program, sort of highlighting that the major issue was maybe being in this community, was setting him back in treatment and starting over in somewhere new would be, an appropriate next step and fresh start. So I'm eager.
Listen, no matter who types in this chat, always listen to Nan. just listen to Nan. Just go get it checked out. Nan said so.
Learn about the program too. If you would put your case manager in touch with me so I can take care of that. He has my email. We've emailed.
Which one are you talking to?
Oh, Murph.
Did you say O. Murphy?
Yes.
Okay. Do you have a caseworker named?
Or O'Keefe. I was thinking Irish, but I have.
I think she thought Georgia O'Keefe is your caseworker.
You told me here at South Street? I don't have a caseworker. I have a counselor. Like my main counselor is Janella.
Okay. You can put Janella in touch with me.
Can we just put the person that is there in contact with your lawyer? And we'll just get this all cleaned up for you, Mr. Vester.
Okay.
Anything else from the prosecution? Let's come back the 21st of August at 4:30. Mr. Vester, I just want to make sure that your restoration treatment is back aligned, and that doesn't get missed here, okay?
Okay.
And let's get
Jacob O'Keefe, just so we have it.
Oh yeah, Jake with.
He quit?
No, he's in sick bed right now.
Okay. Well, let's get your lawyer in contact with someone over there that can help her so she can get things cleaned up for you, okay?
Okay.
All
I
right,
have
my
a
friend.
question. That's what I was wondering about is my CompC classes.
That's what's gonna get re-referred. Yep.
Did they say they'll do that here?
Yeah, so the comp classes are offered all over Colorado. They just have to get the right provider that's near you lined up for you. So when we come back in 3 weeks, part of it is for me to make sure that they've done that.
Okay.
Yeah.
Thank you. And I'm saying that the worst to worst, if they can't do it here, you guys are not going to send me back to jail, are you?
No.
Because I've been working really hard.
No, so I would not be worried about going to jail. They are gonna get you a provider. There's nothing about where you are that is, outside of the scope of where we have providers. You're gonna be just fine.
Thank
So
you.
don't worry about that. Just do what you're supposed to do. The only reason you go to jail is if you don't do what you're supposed to do.
No, I'm good. I'm doing good.
I know, so we're good. 3 weeks is the 21st at 4:30. I just wanna make sure everything's lined up for you, okay?
Okay, thank you.
You're welcome. Have a good day.
Bye.
Giovanni Lopez Chavez, 24 CR 76225 CR 5021 24 CR 5000. He's present before the court.
And he's in my shower.
In custody. Mr. Iddings is present as counsel. And I have Mr. Manuel Larola 22068 here to do interpreting for us. Mr. Lopez Chavez, you will stay on medication.
I took it. I got mad at my kids about a couple months ago. I was in the shower and got mad at my kids because nobody helps me do anything. Never, ever. I never get help. So I they don't deserve this tambourine, and I took it out of the shower to my room.
Oh, yeah.
You will stay on them. Because if you come out of jail and you're ordered to take medicine as prescribed and you stop taking it, then you can go back to jail. And so I need to make sure before we even begin a conversation of whether or not you're going to come out of jail, that you understand the expectation is you're continuing to take your wellness seriously and you're taking medicine as prescribed. Once you don't take the medicine as prescribed, then you go back to jail again. Also, when you don't take medicine as prescribed, you get into trouble. You do well on your medicine, you need to keep taking it. If the doctor changes their mind, it's a different story, but so long as the doctor says you need it, you need to be taking it. Any questions?
No.
One case is holding him in custody, 25 CR 5021 with a $6,500 cash or surety bond. $6,500 cash or surety bond. Are we VRA compliant to address that bond?
Your Honor, is that the Jackson County case?
No. Jackson County's the 5,000 case.
And my understanding is that we're VRA to address bond in that case as well.
I think he's already on bond in that
Now we have two different voiceover actors. Her voice versus his voice.
case.
Yeah, I think he's posted.
I show only one case is still holding him. He's posted bond in the other two. So the question is, in 25 CR 5021, what is the request of the defense?
Your Honor, we would be requesting a high PR bond.
For him to go to work release?
Yes.
All we wait for with this judge, we let them do their thing, you know, the lawyers and the judges talk, and then we wait for these people to say, hey, I have a question. That's all we wait for. I have a question.
Prosecution. Any position from the victim?
Your Honor, the victim, what I have believes, an agreement with regard to work release and the competency court being part of that program would be beneficial for the defendant.
So the victim's in support of the work release?
That's the people's understanding.
Okay, what about your position?
Your Honor, the people would ask to maintain the bond as set. We would note the serious charges. We would note the criminal history as well as the number of FTAs, 16 in the past. Serious criminal history in the past. Multiple felony cases.
But how smart is he? Does he got a huge scholarship to Harvard?
The defendant was on bond in 2 cases when picking up this new case, 25 CR 5021. And there was an active warrant at the time the present case was filed. People continue to hold concerns for community safety. I would ask to maintain that bond.
Oh, that's why. He was talking like that in little chunks, really slow, because I think there's an interpreter. I could be wrong.
How long has he been sitting in custody?
Trying to see if he has headphones on, but
I
it's so
believe
tiny.
it was January, but I will double check.
Giovanni, you can't miss court. Don't you want at some time be out of jail and be in the community and not be involved in court?
Yes.
So your goal is to be out of court in the community. When you miss court, you have to go to jail. That's the opposite of your goal.
I'd like to have an opportunity. And he has been in custody since January.
What accent was that? Did you hear that?
I'd like to have an opportunity.
Oh,
And he has been in custody since January 18.
Giovanni, you've been in jail for 194 days. That's a long time to be sitting in the jail. When you get a new case, or when you don't show up for court, then you go back to jail again.
Yes, yes.
I'm going to modify your bond. I'm going to have you on an $8,500
no, let him
Personal-
talk. I want to hear this interpreter, please.
recognizance bond in 25 CR 5021. The bond in all three of your cases will require intensive pretrial supervision, no drugs, no alcohol, no marijuana, and you'll be giving urine and breath tests to make sure you're sober when necessary. You are to remain law-abiding. You may not have weapons. You may not harass, intimidate, molest, or threaten any witnesses or victims of your case. You are to report to work release. You'll be taken over there on August 4th at 8 o'clock in the morning, releasable to our staff. You are to remain in work release and follow all of their requirements until further order of the court. You are to work with Lauren and Logan and Nick at pretrial and cooperate with any of their phone calls or emails or evaluations. And you're going to take the classes for restoration. Those are the classes that help people understand court better. Can you follow all of those requirements?
Yes, sir.
Do you have questions?
No.
If you leave, you can expect that I will put a warrant out for your arrest. And I don't want you to spend more days in jail, but I will hold you in a jail if you take off. You are to take all medications as prescribed by your doctor as a condition of the bond. If you don't do that, I'll move you back to the jail. If you pick up new cases, I'll move you back to jail. But if you do what you're supposed to, we'll keep looking for different options. Maybe you don't have to be in work release eventually. Don't blow it.
Thank you.
Well, don't thank me. Jail might be easier. I'm trusting you, Giovanni.
I do too.
Mr. Iddings, I'm gonna get us a new date. Not sure how useful that document will be because it's not in Spanish, but it goes over all the rules I just went over. Want me to just check in to see how things are going? The 21st of August at 4:30.
That works.
Giovanni, I just want to check in and see how you're doing. This is converted to an outpatient restoration order on all 3 cases. I'll see you on August 21st at 4:30. You can be virtual if that's easier from the work release program. Do you have any questions?
No, thank you.
You're welcome.
And we've had a lot of pep talks about this potentially happening, and I think Giovanni has really been getting his mind in the right place. And I look forward to you calling me next week, and we'll set up a time where I can come meet with you and work release.
Thanks for doing that, Mr. Iddings. Giovanni, take it seriously.
Thank you.
Thank you. It's 2:30. We're going to start the 2:30 docket with Jacob Johnson, 24 CR 1760. Thank you. Not that we have Mr. Johnson yet. Should I pass this?
No, Your Honor, the DA has agreed that he could waive his appearance today. There have been, so I am ready for the court to call his case.
Go ahead.
So there's been some confusion with whether or not the CMHIP has gotten the order or whether they need a new order. When they got the initial order,
You're talking about for the neuropsych?
yeah,
Okay.
the initial order, I think, was from back in the early part of 2025. They eventually reached out and said they could not do the neuropsych eval until restoration had been officially ordered. So we got restoration ordered. And then at this week's staffing, Isaac was unable to figure out if we needed to re-trigger the neuropsych or not. There was some concern that if the court issued a new order, he would go back to the end of the waiting list, where he should be high up on the waiting list. But neither Mr. Johnson nor his mother have been contacted by anybody at the state hospital about scheduling the neuropsych.
My concern is I don't have a way, he is not here or online to get the new court date and time.
Oh, I'm already in touch with him. We're gonna do a bond acknowledgement.
Okay. Or is there a way to call them and we can just give them the new court date? You don't have to do that and I don't have to worry about that he's FTAing. I appreciate the DA wants to waive, it's not the DA's position or authority to waive someone's appearance before this court.
And if the court, the only reason we didn't do this as an advanced reset is because I just wanted to have the court.
I don't want to even state a warrant on his record, so I don't know if you can get someone on the telephone, I will give the new date. I'll just pass it.
Okay,
I'm not trying to make it harder. I just don't want to lose jurisdiction, and to maintain it, I don't want to put an FTA or a state FTA on your client's record because it's not your client or his mom's fault. I understand what happened. I'm just trying to figure out how to navigate it. So if you could just maybe help me by the end of the docket to get him on the phone.
yeah, that won't be a problem.
Okay, and then I'll just do as you're saying, but it looks like someone's hovering behind you. Yes, what's going on? Yeah.
So just an update from what Mr. Iddings was talking about. Denise had been emailing with Isaac earlier today to try to get an update from CDHS. It sounds like they are working on processing the neuropsych eval through their legal team at this point. So I don't, unless Denise believes differently, we don't think that a new order is necessary for that. It just sounds like it is being processed. It's just going to take some time to work through the system.
I can't remember, this was probably a neuropsych that the eval was recommending. So I thought that that is okay, but your legal team is going to review it.
CDHS that's the terminology that they used in their email this morning. So it sounds like they are processing it. It's just,
Feels like your legal team has different things they should be working on.
I would think so as well.
He's standing up right behind you. I won't order anything else. I'll let it take its time that it needs. I don't know if there's I don't think that they're a contracted provider, but you know, even Colorado State University does neuropsychs. And if there's a way for us to help them get a neuropsych sooner, then it might expedite the case so that he doesn't have to be in the system for as long. So whatever you can do, Isaac, I know you'll do it. Okay. How far out is it recommended to, once we get him on the phone, reset this for?
I think we could probably go at least, Your Honor, yeah.
Yeah, like 10 weeks,
I think we could go longer.
like 10 years. We'll do 10 weeks. At least you give me an update of what's going on. I know we won't get the neuropsych by then, but at least we know what's going on in case you need a different court order, or let me know in the meantime. So once you get him on the phone at any point, just let me know, and then I'll recall his case. Okay, thank you. And then are you Mr. Loaiza? I'll call your case next. Claudio Loaiza. 25M353 is present before the court. He's in custody. Mr. Iddings is present as his counsel. Nice to see you. How are you doing? You're busy working in the jail. What are you doing?
Kitchen worker.
Still kitchen work? I think last time you told me you were doing kitchen work too. Weren't you inmate worker last time you were here? No, this is new? Okay, when did you become inmate worker?
A week ago.
Oh, congratulations. Yeah, that tells me a lot about how things are going in the jail when you get picked to be an inmate worker. So well done. Thanks for doing that. All right, and so Mr. Iddings.
Your Honor, I've been on Mr. Loaiza's case for a while, and he was initially interested in the wraparound program when we believed that he would be able to potentially get a PR bond sometime in June to start participating in that program.
Okay.
But now, after having talked to him and with the wraparound taking a while to roll out, and also from talking to his Weld County public defender who had concerns that they weren't going to be able to get him a PR bond over there, despite the fact that he would be doing a wraparound program here. At this time, I'm just going to ask for an evaluation to be ordered.
Okay. So Mr. Loaiza, the evaluation I'm going to order for you is so that I can read a report to understand how much you can help defend yourself in court. So in the United States, when someone is accused of a crime, I have to make sure that you can defend yourself adequately. That's all the evaluation is for. Okay. So when the doctor comes to meet with you, get this eval done, know that they're producing a report, so it's not a private appointment. And if you want to talk to Mr. Iddings before you meet with the doctor, that's fine. Okay. And we'll get this thing done for you, and then we'll bring you back to court. And Mr. Iddings, that next court date, I guess, Isaac, is it about 6 weeks to get an in-custody eval done? Do you think, Isaac?
That's about.
Okay, then I think let's also go to the date of September 11th. We'll set it in at 2 o'clock. And Mr. Loaiza, if I get the report sooner, I'll bring you back to court earlier. Okay, and Mr. Iddings will let us know because this case we can bring back sooner if the eval comes. Keep up your good work.
Thank you.
Thank you. Good to see you.
Thank you.
And in custody virtually is Alyssa Smith, I believe, 25 Sierra 135. Deputy, is that Alyssa Smith?
It is, Your Honor.
Thanks for your patience. I do have Mr. Iddings in the courtroom, Ms. Smith, as your lawyer. Obviously, you're appearing virtually from our jail. And yeah, Ms. Smith, I got your evaluation back. So I'm glad that you got the eval done. And I just had some concerns about your safety and your health and wanted to kind of figure out how best to approach moving things along with your cases. So Mr. Iddings and Mr. Gipp, it sounds like I have findings from Dr. Arzumanian, and I can adopt those findings. My question for the team was what level at tier 1 she may be. I have learned that Ms. Smith can do better, but also has gone through some pretty substantial deterioration. And the self-harm behavior has gone all the way to the point of drawing blood, and she's had to have her wrists or her arms wrapped. One of these attempts on her own life was so serious, she had to go to a hospital for assessment and for observation. The impulsivity and acuteness is of high concern. And despite taking medications a little more often, she is in lockdown for a facility-initiated protective custody. All of this stuff is for there to be a special management plan from our jail, but really she needs to be at the state hospital. And it looks like there are reasons why she should be adopted as a 1A, but Mr. Iddings, I didn't know if you visited her, if you have any additional record you could help me with.
Your Honor, I did meet with her last week, and then we met again this week and reviewed the evaluation. Ms. Smith, I've also been in touch with your father in Maine, Darren. He sends his love and is thinking about you. And we do think that the court should adopt a finding of both ITP and Tier 1A.
Prosecution.
People would have no objection to that, Your Honor.
Court at this time, based on the record that's being made, will adopt the findings that you do need extra help to aid in your own defense, Ms. Smith, against these allegations. And that the designation should be Tier 1A. That means you should be moved for extra support and help as quickly as possible. That is the fastest I can try to get you to some extra support and help. And so I'm issuing that order. I say that to you, but because of the state of the crisis for the competency, it's still going to take a while for us to get you help. Please do your best. I know you take your medicine more regularly, but try to work with the doctor and be consistent with medication management. I am worried about you, and I want to make sure that you're healthy. I can bring this back. Mr. Iddings, I don't know that there'll be any fruit in bringing it back even in 2 weeks because she has to have a female bed. I know what the statute says, but we know we live in a different reality than what the statute says. Wondering if I set it out a little ways, if you would be okay with that, because they can move her along the way. But I'm wondering if I set out little ways, and order that the presence of the Attorney General and a representative from SimHIP be here. Can I set it on the docket of the 28th at 1:30?
I can accept that.
Let's set this for August 28th at 1:30. Isaac, I am making those findings. I know the circumstances that the state's working with. If you could let them know that we would like to have a representative, if she hasn't been moved, to explain why that is at that date and time, or maybe kind of a trajectory of where she sits, that would be helpful, but let's give them a little bit of time. The 28th, the 28th at 1:30, because I'm trying to be sensitive to their challenges. Hopefully they will be sensitive to Ms. Smith's. All right. Okay, Ms. Smith, are those tattoos on your arm?
Yeah,
What's your favorite tattoo?
the rose in the heart.
Okay, why did you get that one?
She's my best friend.
Okay, so it has emotional significance. Okay, well, I'm sorry that you're not here today. I look forward to meeting you in person. I don't know, you may not have heard when I introduced myself, I'm Judge Blanco, and I'll just be working with you to help you through this time. And next time when we come to on the 28th, I'm hoping we'll have some better answers. And if you can be here in person, I welcome you, okay?
Yeah, they just leave me in there for hours under the coordinated shackles and it hurts my ankles.
I'm sorry. I'm sorry. I'm gonna do my best to try to help you get moved. This isn't gonna be a challenge. We're both gonna be in it together. I will do my best to do that along your side, okay?
Okay.
All right, I'll see you on the 28th.
Okay. Goodbye.
Thank you. S. Roby, 23 CR 1786, 24 M 701, 23 M 2861. Ms. Lowry, should I, he had surgery today, so I'm gonna call his case. And there was a motion asking to waive his appearance.
That's right, Your Honor. He is scheduled for surgery today. The only reason why we didn't ask to just continue it out to another date and why he gave my permission in writing in a filing I sent to the court to appear on his behalf is because the district attorney is requesting a second evaluation and we wanted to get that process started. So
Is it true he had brain surgery today?
it's at 3 o'clock.
And so, I don't know, after someone has brain surgery, it sounds like the recovery is at least 6 weeks and then we're doing another eval. I don't even know if the DA still needs an eval after the brain surgery. I'm not sure how the brain surgery is going to go. Should we have a status maybe and see?
I think that might be appropriate. I think, I'm not sure that Mr. Oxmacher was aware of that at the time, but he was in discussions with a doctor that might do that second eval. And so he was trying to secure that doctor before making that request. But
My understanding is the recovery is going to be at least 6 weeks, if you want to let Mr. Oxmacher know. And I don't think people are questioning whether or not he is ITP, but rather whether or not he's restorable. And so, let me order Bridges in 24M 701, 23M 2861 to clean that up. For whatever it's worth, he's doing really well with pretrial services. I'm going to remove the requirement for his substance testing. Well, I don't know if I can. Hang on a second. Nick, is it on all 3 cases? Because I think that 2 of these, well, are they all VRA? 2 are VRA. So technically, it looks like he's in non-compliance, but he's not in a place, obviously, to be able to go give testing right now. I can't remove the requirement without VRA unless it's only in 24M 701, is it? in any of the other cases?
I have substance monitoring in all cases.
Okay. I'm gonna leave it alone, but prosecution, if you want to make note, that means he's in non-compliance and I'm not gonna act on it, given the circumstances.
Understood, Your Honor.
I did sign something, Your Honor, that I submitted that accepted a court date in September, on September 25th at 2:30. But if you wanted to bring back an earlier court date, I'm not sure I have any ability to give it to him. What I filed just gave him that.
Let's just do your date, September 25th at 2:30.
Great.
Let's let him heal. I'll order the second eval today because it's been requested. I just think we're gonna have to be nimble on this case. I just don't think the DA is gonna get an accurate understanding. Well, I don't think any of us will if we push the issue before he's healed. And then I guess Mr. Gibb, maybe once Mr. Osmacher's at a trial, you want to talk to him about the circumstances, because it's just unusual.
Absolutely.
Sure. And then on the 25th, we'll kind of be ready to pivot. I hope he's doing okay.
Thank you so much.
Thank you. If you want to be very compliant on the substance monitoring, that way we don't accidentally get an affidavit for him. Mr. Gibb?
Yes, Your Honor.
Yeah, okay, thank you. And if you want to file something, the only thing I want to know is if I can remove the substance monitoring, because it's obvious. Okay, and then.
For instance, Mr. Roby, there's still a couple of cases that don't have written orders.
I ordered them in the 2 of the 3 today. Are there more cases that should do it? Okay, we got that covered. Thank you for making sure. And so actually, I think that we are in a place where we can take a 10-minute recess and then we'll reconvene for the 3 o'clock docket.
All right, we did it. We made it through a part of her mental health docket, which, we met some really smart people here today. Very smart people. Guys, thank you so much for coming out today. I really appreciate it. You'll be popped over to OJ. So I hope you have a great day. I'll see you all later. Bye.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night, when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Street of tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes near a sky so blue. In her jokes, there's a truth so true. With each stream, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's laugh